Well, I think it's very important for us to share some light on this entire debacle that we are finding ourselves in. I think it is important for us to understand that the Resolution 1 of 2018, which is a 3-year wage agreement, is clear in terms of clause 3.3 that the employer is obliged to implement the salary negotiation or the wage increment for the public servants in terms of Resolution 1 of 2018, clause 3.3. The employer now arguing in the following to say that the agreement is unlawful. They did not have a mandate to sign such an agreement. At this stage, that's why the PSA approaches the court, because the collective agreement is a binding document and it's actually a contract between the employer and the employees. So why the PSA have approached the Labour Court in this instance is to enforce the collective agreement in terms of our current labour law, which allows for that. Well, we say, if they say the agreement is unlawful, why did they implement the previous 2 years? So what are they going to do then? Yes, they're arguing furthermore to say that the cost factor, the financial status of the country is a big issue on the wage dispute, which the PSA hear what they're saying, but we're saying, if you say there's no money, what consequence management have you implemented with the corruption that is currently all over, which is all over in the news? Not only the corruption, the purchasing of the PPEs, how was that done? There is no consequence management. The frivolous litigation processes that the government instituted, that is the things where the employer could save money in order to afford the wage agreement. And even that, I mean, they need to implement the wage agreement. They cannot negate from the wage agreement as they are currently indicated. We did draft a letter to the Registrar of the Labour Court, which we have recently received a set-down notice at the Labour Appeal Court. Now, a lot of questions is why the Labour Appeal Court? Because that is not normally what happens. The matter first gets to the Labour Court, then the Labour Appeal Court. But the letter from the registrar clearly indicated, due to the abnormal circumstances in this matter and the attention that it seeks and the volatile situation outside and the interest in this matter, they have agreed that this matter will be set down on the 2nd of December at the Supreme Court of the Labour Appeal Court as a court of first instance. So we are hopeful in our legal processes, and we trust that the Labour Appeal Court will do justice to this matter, and the PSA is hopeful that we will have a positive outcome on this whole process, and that the Labour Appeal Court will rule in favour of the PSA to say that this is a collective agreement which is binding on the employer and they need to implement it. Well, it will all depend. I don't think we have to preempt what is going to happen, although we are very positive that the Labour Appeal Court will rule in our favour. If the employer still can say, but we do not have money, they will have to find money. We don't know where they're going to find money, because this will have a huge impact on collective bargaining in its entirety if the employer if the court is going to allow an employer to negate from a collective agreement, because it will have an impact on all collective agreements that will be entered into in future. And that is what we have to fight against, and that is what we need to stop before the employer can come with situations. Yes, there's a lot of indications. The arguments that the employer also use, especially the National Treasury in their papers, might also latch to constitutional matters that we will have to look into. But that is a debate for another day, and we will have to wait and see what will the outcome be of the Labour Appeal Court on the 2nd of December. We are really struggling in all sectoral councils. Each and every time the employer come back and say they do not have a mandate to engage. And this is already an indication that there is an attack of collective bargaining, which we need to protect with everything that is within us. Because how are we going to establish new rights for our members if collective bargaining is going to die out? We cannot allow that. And that's why we said we will have to use the current legislation which is applicable to us, to make sure that this case will be a watertight case, and that we will ensure that our members' rights and interests are protected throughout this whole entire process. Currently, the PSA have obtained inputs from our constituency regarding our new wage demands for the year 2020-2021. We are busy consolidating our demands, which will be tabled, we envisage to table it by the end of October. And then we will have to see what will come out of that process. I mean, if the employee come and have their strategies, or the employee trying to prevent us from engaging, we do have the law on our hands, and we will have to consider the necessary measures or the necessary steps to force the employer to the bargaining tables.